All right, hello and welcome. I see we're recording, so I think we're on now. Hey, Billy, how's it going?
Hey, I'm doing all right. How are you?
I'm doing good. We're wrapping up the end of April. We've had a lot of new interest in Win Without Law School. I think we had around 100 people join the email list just in the last week. So,
Oh, that's so exciting.
yeah, so it's really growing. And if anybody out there does want to join the email list, just go to winwithoutlawschool.com. It's free to join. And we'd love to see you there. So we meet once a week and we talk about a different family law topic, and then we get into Q&A. So if you have any questions, feel free to throw those into the Facebook group. I think that's the best avenue right now. And Billy, I thought it would be fun today if we started by just kind of giving a little history about each other. Like, how did you get to where you are today, for those of you who don't know your story?
Yeah. You mean, well, why don't you go first?
All right, I gotta put you on the spot there. So I am from Scottsdale, Arizona, originally, born and raised. And after, like, in high school, I was already into lawyerly stuff. Like, I was on the speech and debate team, and I went to competitions and stuff, and like got really into that. And so there was definitely a part of me that had, this lawyer trait from the beginning. But I was never one of those people who had set the goal and was like, I'm going to be a lawyer. Like, I didn't know that, even though in retrospect, it's like, oh, of course you were going to be a lawyer. But I didn't like draw that line in the sand or anything. And so I did end up going to law school, went to ASU, and initially I studied environmental law, and I thought I was going to be an environmental lawyer and fight for the earth. But it turned out to be so boring. Environmental law takes decades to really make a difference. And I just found myself sitting behind a desk because I'd done some volunteer work and externships, like stuff to get some experience in that area. And I hated it. And so at the very end of my law school, my time in law school, I pivoted and decided I wanted to be a trial attorney. And I became a prosecutor, and I decided to go out to rural Arizona. So I went to this small town called Parker, which is in western Arizona. It's on the border with Arizona and California. And it is like small town law. There's one superior court. There's one superior court judge. I worked, right down the street from the courthouse. I mean, I wasn't even right down the street. It was in the same complex. I could just walk to the courthouse and back. And they have a big need for lawyers. So I did like everything. I was doing trials. I was in all these different courts. I was doing child support stuff. I was doing felonies, misdemeanors. I got to do a lot. After a year there, I was like, oh, I'm ready to do something else. So I moved to Flagstaff, and I worked as a prosecutor there for a couple of years. But it was just at the city court level. And it was good in that I got to do some jury trials. So, DUI type stuff. But it also was really boring because you prosecute a lot of traffic stuff. So, driving on a suspended license and, just stuff like that. And it got a little monotonous. So I ended up connecting with a lawyer I had met out in Parker and went into private practice. And for the next 6 years, we worked together, and he was an amazing mentor to me. And I did a lot of different areas of law. I was your typical small town lawyer. And I was fortunate enough to have some really just amazing cases. I had a custody case that went all the way to the United States Supreme Court. My arguments prevailed at every level of the court system, from the trial court to the appellate court to the Arizona Supreme Court to the United States Supreme Court. That was such an unexpected journey. I represented the mayor of this small town called Quartzsite, and the Wall Street Journal wrote an article about it and called me and quoted me. And so I decided I had a lot of unique experiences. And then on top of that, the lawyer I worked with was really magical. He was a pilot before he was a lawyer. So he had a small plane and we would fly places together.
Wow.
And I remember one time we were flying to Flagstaff and we had just gotten to, altitude, and it was like the first time in months I had felt relaxed. And I was just enjoying, flying through these beautiful clouds and this wonderful trip. And he turns to me, he says, "Julie, what would you do if I had a heart attack right now?" It's just like, I don't even, and then he's trying to tell me what to do. And I'm like, I don't even want to hear. I can't concentrate right now. You've got me all freaked out. But luckily we made it to our destination.
Here you are having this lovely time and he goes and ruins it.
So we had a lot of fun together. But after a while, it was just a very isolated location. And so I decided to relocate to Sedona. And I was in between Sedona or Flagstaff, and a lawyer passing away actually brought me to Sedona because I was looking for office space and there was an ad that came up for a lawyer's space. I didn't buy his business, but I did take over his law office, and he had recently passed away. And so that was interesting. I swear his spirit was haunting the office at times. He kind of died unexpectedly. And I swear at one point he knocked over a huge bottle of water on my desk and ruined some stuff I was working on.
Wow.
But yeah, and then I've been here for 7 years as of this month. So just done a lot of trial work, a lot of family law work. And one of my favorite parts of coming to Sedona was a shift in my perspective as a lawyer, to where I started to see some people's legal problems as just being things they need to go through, life experiences that they need to have, in particular, like a divorce. It's a rite of passage in a way. And, I'm helping them on that journey, but I'm not necessarily responsible for, saving them from going through that rite of passage. So that's a little insight on my journey. How about you, Billy?
I loved that. Thank you for sharing that. So I have always been kind of a feisty, a little bit righteous, really hate authority and bullies. Like that is just like, that has been my essence since I was a little girl. So I always knew I was going to either be a lawyer or a singer. I also sang and perform and did that for many years. And it's so funny because I just got out of a 2-day trial for the last 2 days, and it's so much like improv and like performance. It's so similar. Like you're putting on a show, you're holding court, it's really fun. It's really, really fun when you love your clients and love your work and believe in what you're doing and can kind of connect that to you, like to what makes you feel like you're a useful individual. Caitlin just brought me some coffee because I'm struggling. But so I wanted to go to New York and go to college, and my parents and I were on the rocks, and they kind of like sort of kicked me out of the house at 17. And we're like, "You're going to college early because we don't like you living here." And then I had to go. And then they were like, "And you can't go anywhere except for staying within the state." So I ended up at a state school because of that, and knew that, Broadway and those dreams weren't going to happen. And so immediately upon entering college, I knew I was going to be a lawyer. I finished college in 2.5 years and went to law school because I'm very focused and goal driven. And then my parents went through divorce about that time. And that is when I got to see how lawyers can impact real people. And like you said, like originally I wanted to do international rights, human rights. But when I saw my parents divorce and realized like just how real and human it is, it just spoke to me. And I was like, I want to do that. People need help. Lawyers make a difference in people's lives and in families' lives forever. I want to do that. So I've been only a divorce attorney my whole career. And was in Oregon, got married in law school, and then moved down here with my ex-husband and opened modern law thereafter. And I just have such a passion for business and for law and for family law. And I really love what I do. I just love it. I think, I woke up yesterday and just felt very honored that someone would give me this role in their life. And it's kind of like you said, the role is a special role. And you're not there to save people, but you are there to advocate for people. You are there to help balance power.
Mhm.
You are there to protect people's rights and help be a voice, because not everybody is born to be a feisty, provocative, like stand up for what's right person. And so having the ability and the honor to represent clients and help them tell their story and help advocate for them is just something that I truly love and cherish.
Yeah, and that I think really spills over to Win Without Law School, which is a passion project that we started late last year, where we're trying to share these skills that we've learned with people who are going to represent themselves. And whether, they're doing it because they want to save money, or whether they're doing it because they're just out of money, whatever their motivation is, you don't just have these skills. You don't just understand trial procedure. You don't just know how to tell your story in a compelling, provocative way that matches up with the law and the procedure and, law speak, so to say. So that's what we are sharing, is what we've learned over, these nearly 20 years of our individual careers, and helping people help themselves in a really powerful way.
Absolutely. I love it. I love that it's growing. I love that it's helping people. And it's another option. So if you all have not checked out Win Without Law School, absolutely check it out. I love that we're offering this 2 weeks for $1. A lot of people are taking advantage of that. And you're really getting in there and getting a lot of great information. I'm having Julie do a workshop with, we're running an internship program, and Julie's going to run a workshop with our LPs and our interns. And that workshop is going to be so awesome. And they're going to get to teach and practice skills, and Julie's going to coach them. So it's going to be great stuff. Is it now a good time, you think, to transition?
Yeah.
All right. So I know that we've been talking about ourselves, but my name is Billy Tarasio. I'm an Arizona family law attorney. I own Modern Law in the Phoenix area. This is Julie LeBenz. She owns LeBenz Family Law in Sedona. And almost every Thursday, we are here talking to you about family law information and then answering your Q&As. I'm glad that we got to do that background. So for about the next 15 minutes, we're going to talk about what it means to win in family court, and then we will dive into your questions. Everything we're telling you is not legal advice. It's just information. We don't become your lawyer. We're talking about this from an Arizona perspective. And I think that about covers all the disclaimers. Go ahead and send your questions in Facebook, TikTok, YouTube. We'll get to them.
Yeah. So, all of us grow up watching these legal dramas on TV or in the movies. And when you see portrayals of the law in the courtroom on TV and in the movies, it's usually some major victory, right? The David and Goliath story, and the little guy prevails over the big guy, and, everybody's vindicated, justice is served, and it's wonderful. But that is not the family law courts in my experience. Right, Billy?
Right. For so many reasons. And again, I'm just going to use yesterday. So my client, it's been 2 years, and she finally got her day in court, and 2 days, and it's been hell. And she's like, I thought I'd feel more relief. And I told her, I remembered, getting my divorce decree a year and a half after I'd filed for divorce. And I didn't feel relief either. I felt, sadness, not sadness at the outcome. The outcome was fine. But like you said, that this kind of rite of passage, this process that you have gone through, it's like you're happy it's done, but it's also, it's also heartbreaking.
Yeah, definitely. I think a lot of divorce and custody is about, connecting with what's important to you, determining what you need to love yourself, and then pursuing that and getting that divorce decree, I think, can be a major symbol of you really standing up for yourself in a unique way. But the outcome is intended to be balanced between the two sides.
Mm.
The divorce court is what we call a court of equity, a court of fairness.
Mm.
And every judge I've been in front of, for the most part, is looking to give a little bit to each side. It's a no-fault divorce state, so no matter how angry you are at the other side, that doesn't necessarily mean you're going to get any additional benefits out of the court because somebody engaged in bad behavior. And, a lot of people, especially with divorce, have this is mine, that's theirs mentality, like, oh, well, this was what I worked for, and this is my retirement account, and this is, my car. But under Arizona law, it's not just yours, it's the marital communities. And so there can be this feeling like, oh, I can't believe I had to share that with him or her because that should have been mine. And yet that's what the court's going to do, first and foremost, is look to equally divide everything you have.
Absolutely. It is a court of equity. There are two main principles, main principles on property issues. The main principle is that any community property, anything anybody acquired during the marriage, is going to get divided equally or almost equally. That's concept one. Concept two, best interest of the child. We're going to do whatever is in the best interest of the child. And so what we don't do is we don't balance your child's parenting time and decision-making is not subject to, in Arizona, a legal presumption that is everybody gets 50-50 regardless. And I think that's important because there are some states that have that presumption.
Right.
Just a little scary. That is not the case in Arizona. You get to talk about best interest. Now, that does not mean the courts are starting from a place of a philosophical and research-based opinion that most of the time, if you have two good parents, you should have equal time and equal involvement. But if that is not in your child's best interest, you still have that ability to argue. So for instance, in the case I just did where we're talking about relocation, the court's not going to say one parent gets decision-making and one parent gets to be the primary parent. That's not the type of balancing that a court's going to do.
Yeah, and another point that I want to raise is any time that I have had what could be deemed a landslide victory, it's caused a lot of problems because the other side appeals, or the other side does motions for reconsideration and Rule 85 motions and Rule 83 motions, and the litigation just goes on and on and on. And then there's more fees, and then the big victory you had is at risk and often ends up getting changed. And so even though it can feel really good to get that big victory, I often find that that good feeling is short lasting because it then comes under attack, and now we're litigating again for another 6 months to figure out what the final order should be, and it's quite frustrating. So sometimes it's not even beneficial to get the big victory.
Yeah, I haven't had a ton of big victory cases be appealed. But what I have had or experienced is a lot of big cases that don't get fully resolved. And so they just keep going. For instance, the judge won't divide all the property, or the judge will not make a ruling on an issue that's really important, or, the parenting plan will be written in a way that is impossible for both people. That happens. And so it isn't unusual for these high conflict cases to go well beyond the trial and the ruling.
Mhm.
Almost,
Yeah.
you can kind of expect, like what you said, a good 6 more months of cleanup, but at least it settles down. At least you don't have to prepare for another evidentiary hearing, usually.
So yeah, I think a lot of people go into a family law case, be it a divorce or a custody case, and sometimes have unrealistic expectations about what the possible outcomes are. And so I think that this discussion is helpful to kind of give people this idea of, even if I have the best facts and the most compelling arguments, that doesn't mean that the court isn't just going to divide the property 50-50, and that the court isn't just going to give us equal custody. And that can be frustrating sometimes when, you want the court to do something different, but getting the court to do something different is challenging.
Yeah, absolutely true. Yeah, it's hard to determine what a win is. Like if you win some issues, but you lose some other issues, have you won? If you win a bunch of issues, but you lose the only issue you really care about, have you won?
Yeah, and that's another reason to look to try to settle your case, because the judge is likely going to try to give something to each side, and how is that going to fall? That's something you won't know, and that's totally out of your control. So finding ways to negotiate and bring your case to a resolution can be helpful. And then I think one other thing as well is, how do you deal with the waiting period from when you've had your trial to when the decision comes
Yeah.
out?
Yeah. What I want you to talk a little bit more about that. How do you handle it? How do you see people handle it?
So this came up a bit during our Q&A in Win Without Law School, where one of the participants had gotten what she perceived as an adverse ruling from the judge, and now there's one final pending issue for the court to rule on. And even though the court hasn't made that final ruling yet, she's like, oh, it's going to be the worst, and I'm going to get hammered, and how am I going to handle this? And she's already living in this world where the worst case scenario has unfolded. But going back to our discussion today, it's rare that a judge really tries to hammer somebody in these cases. It can happen, but it's not the most common thing.
It's rare.
And
Even
so,
when they should, even when you fully believe that somebody should be hammered, it usually doesn't happen.
And so, of course, we'll see what the final outcome is for this particular case, but I'm anticipating the outcome isn't going to be as bad as she's anticipating, and the judge will, not necessarily give her the best ruling, but it also won't be worst case scenario. And so, let's see what happens. But I know it can be really tough to wait until the final outcome is here and not just start speculating about what it's going to be and then feel good or bad about it.
Yeah, I recommend just being super positive. just believe the best, because you don't know until you know. So you might as well feel okay about it until you know. I know that that's easier said than done, but sitting around and thinking about how things are going to be so bad is not going to help you at all.
Yeah, I completely agree. And I find that's how most people approach legal problems, is they go instantly to the worst case scenario and start fretting and get scared and things like that. And it can be hard because there's a lot of unknowns. But at the same time, it's like, okay, explore that, maybe put together a little plan of action around that, and then leave it and focus on the good stuff, because just dwelling in that bad place is only going to, stress you out more. And so I'm not saying you can completely ignore it. I don't know if that's realistic. You may have to analyze it a bit, but once you've done that, like, move to a more positive space, because, what else is there to really analyze after a while?
I think that's a great point. And honestly, if you're going to court, some part of you needs to wrap your head around the potential outcomes and what you will do in each of those potential outcomes. So maybe having a plan for, whatever it might be. If the worst case scenario is I don't get enough child support and spousal maintenance to live on my own, to pay my bills, then maybe you should have a plan for, so here's what I'm going to do. I'm going to move in with my parents. I'm going to get roommates. I'm going to know that whatever it is, you got this. And then there's no need to worry. There's reason to plan, and planning feels better than worrying.
Exactly.
I think.
Yeah. I mean, it's one thing to just think positively, but then it's another thing too, to, take some action that supports, the plan, or, having some sort of backup for yourself, because there are a lot of unknowns. And again, this is a great reason to try to reach a resolution, because it does give you more control over the planning steps.
Absolutely. And sometimes people are ready. One party wants to settle and the other side is simply not emotionally ready. Sometimes what you have to do is be patient with them and live in limbo, which sucks. I get it. I do. You're ready to move on. You're ready to make concessions. You're ready to do what's right, do what's fair. And they're like, but my world just fell apart. They're not ready to talk about or to plan. They have to grieve. And sometimes it takes a long time and you have to wait a while for that to happen. Have you experienced that?
Yeah, I definitely have experienced that dynamic where one side is ready and the other side isn't. And I've represented both sides.
Yeah.
And I find with the people who aren't ready, there's this question of what are you hanging on to? Because if the other person is not here with you, then you're holding on to some vision of them that isn't the current reality. So what are you really holding on to here? It sounds like it's a false reality and not, what's really happening.
Or your old life,
Yeah. And then for the person who's ready to move on, it's like, okay, well, do you really have everything set? If you have kids, how about you test out this parenting plan for a little bit instead of finalizing it? How about you see how this is all going to work before we get this finalized? So yeah, but it's interesting. And I, that is a pretty common dynamic.
All right, let's move to some Q&A. Question 1, what can one ask for? So what do I ask the court to do when the stepmom won't stop overstepping, spanking the kid, thinking everything has to go through her first? And what small details could be asked for so that there's no loopholes and it doesn't get dragged out?
So this is a stepmother. So the court doesn't necessarily have jurisdiction over a stepmother. If you have papers in place, is there a right of first refusal? Is there any argument to be made that you need to have the right to potentially take the kids instead of them being left with the stepmother? Certainly there can be an argument that, if dad allows stepmother to do these things and he's aware, then a neglect accusation could be made as to dad's parenting. It's just, a lot of this stuff gets into the details, and what are the exact details? Here, do you know for sure, because you're not there? Are the kids giving you accurate information or not? Depending on the age of the children, they're not always able to give you a very clear understanding of what's happening. What's the frequency? What's the degree? I think that courts really struggle with these allegations of spanking, because there's such a wide line between what is okay and what's not, and what really happened and what didn't. So it's a tough road here. But I think ultimately, what are you wanting to change? I mean, obviously you don't want your kids subjected to abuse, emotionally, physically, spiritually, any type of abuse. But are you wanting more parenting time? Are you wanting, getting the court to order stepmom to do anything isn't realistic. So how are you going to accomplish that in kind of a roundabout way?
Right. But I would say if you have concerns about spanking, it's usually fairly easy to get a no corporal punishment provision in your parenting plan. So I don't know that I would go back depending on what's going on, obviously. Depending on what's going on, you may or may not be going for a modification on this. But if you do have these concerns, I would make sure to bring them up and make sure to put into the parenting plan that everybody agrees that there will be no corporal punishment. It's a reasonable restriction. And even if it's there are some parents that are just prone to spanking and may still, but I think it will diminish the frequency. And the other thing I think you can do, I know you asked what can you ask the court for, but I think one of the things you can do is make your record and advocate for your child, which means emailing dad. If stepmom wants to be included, include her, CC her and say, listen, I heard this is not okay with me. We need to talk about it. Like every time, make your record, be your child's voice. I think you can do that. And I know some people think like I'll make it worse for my child. That is, to me, it's a little bit like if I tell the secret, I'll get in trouble a little. Like secrets, shining the light on things and calling them out is what reduces bad behavior in my mind. And so I would recommend you set those boundaries.
Yeah, and regarding that term about no corporal punishment, you don't necessarily have to go back to court for that. If you can get your co-parent to agree, you can make that slight change upon agreement.
Mm-hmm.
And I think that's good evidence to try to gather. I mean, whether they say yes or no, I think that's good evidence. If they say yes, it goes in. If they say no, then if you do take this issue to court later, I would be showing that to the judge. Look, I asked for this very reasonable provision and he wouldn't agree.
Right. And then you can ask why. Why wouldn't you agree to no corporal punishment? What is it that you think is so necessary? Like ask, get the information, get those details. Think like a lawyer, join Win Without Law School, and then you can suck details out. Next question. My ex isn't following the temporary orders, hasn't been for months. He takes his parents down whenever he feels like it, and it's making it difficult for me. I am in Win Without Law School, but I'd like to know what forms I specifically need to enforce my parenting time, or to enforce his parenting time, essentially, and modify the time so I can go back to work.
So, okay. You can potentially, I think, ask for an enforcement or a contempt action. This would be failure to follow a court order, so you could seek contempt. But I think that there's a bigger strategy question here. Are you wanting a certain parenting plan where the fact that he's not following this order supports your ultimate request? Do you need to utilize daycare services when he's not following through and now you have a claim for reimbursement because he's not following the order? I think a lot of people just want to run to the court for enforcement, but I think there's also a bigger question to ask about whether or not the particular potentially enforceable issue could be utilized in a different way to help you meet your case objectives.
That's a really good point. That's a really good point. And I've never seen a case that was contempt for failing to use your parenting time. But I'd like to know more about that. Have you seen that?
No, I haven't. And I think, that's the big question of, do you really want them to have to exercise this time, or do you want their failure to use it to be, a point to use in your case to support whatever ultimate parenting plan you want?
And I hear you saying, so I can go back to work. So it sounds like you need a remedy that's going to offer you certainty. I get that. And if you were in this situation where you were going to file for contempt and say, this person's missed parents' time on this day, I would also include your damages. And damages is a legal term, but what I mean by that is I was unable to go to work. I lost out on X amount of dollars because this person didn't exercise their parenting time, or I needed to hire a babysitter and it cost me X number of dollars, or I was unable to get a babysitter or something like that. If you can quantify in damages terms how much this is costing you, which I know is not like, it's not equivalent, right? Missing parenting time is not just about money. I get it. But courts are kind of set up in a way where they order damages. They give you restitution. They provide money in exchange for your suffering and inconvenience. The next question here is, if we have an uncontested divorce and we plan to have a paralegal fill out the paperwork, do we have to calculate our own spousal support and child support, or how do we determine long-term support, or does a judge do that when they grant the divorce?
So if you are going to do an agreed upon divorce, so you're going to reach an agreement on all issues, then you need to reach an agreement on all the issues, and you're going to need to determine spousal maintenance and child support and division of property and parenting plan, legal decision making. And, you know, within spousal maintenance, it's what's the amount to be paid per month and what's the duration, for how long is it going to be paid? Will it be modifiable or not? Child support is running that child support calculator and seeing what it says, but you also need a parenting plan. You know, are you essentially equal, or do you need to calculate the parent with less parenting time, their total number of parenting time days per year? So you can certainly work with a paralegal, and they can help you with the forms, but they're not in a position to give you legal advice about what you should do for spousal maintenance and child support.
Yeah, that's right. So we have certified legal document preparers that work with clients through our sister company, I Do Over. And the reason is that certified legal document preparers who are paralegals certified to do documents are not allowed to work under lawyers, which is a strange rule, but that's the rule. So that's why we have that through our sister company, because they cannot work for lawyers or for a law firm. They absolutely can help you draft your uncontested agreement. They can help you put the numbers in the child support calculator and put the parenting time in the child support calculator that you've decided on. They can help you run the draft spousal maintenance calculator and explain and ask for the information that you provide. But like Julie said, they can't tell you how long should this last. You know, how much should I ask for? How do I make my case? They can only help you draft an agreement that you already have, and they can provide information to you that perhaps can help you make that decision. The other thing you could do is get a consultation with a lawyer if you have questions on those things. Next question: if you have a provision that prevents corporal punishment, how is that enforceable?
Well, if that has been signed off by a judge, so it's part of a court order, then you have the ability to seek to enforce terms of your court order. And when you seek to enforce, you, number one, have to show the underlying order that the other side knows. And then you need to explain how they violated that part of the order. And then the third and one of the most key parts is explaining what you want the court to do about it. Because not every violation has a remedy.
Mm-hmm.
And so there could be 100 violations, but if there's really nothing the court can do about it, then it's really not worth taking to court. You know, let's say your co-parent is constantly late for the parenting time, but it's not causing you to miss work. It's just inconvenient and frustrating. You know, what do you really want the court to do to remedy that? Like slap on the wrist? You know, there's not always a remedy for every harm. But if you are going to go to court and seek an enforcement action, you need to be clear on what you want the court to do about it.
Right. Yep. And it's really helpful if you tell the court how to solve your problem. So for instance, if this person's late picking up, then perhaps you want to change the location of pickups. Or perhaps you want to build in, you know, let's say you change the location of pickups and you do it at the childcare providers. And then, you know, at a certain time, the clock starts running and dad or mom is on the hook when they're late. Like, we can build things that practical boundaries that protect you and that solve your problems. But you're going to be better off either figuring those out yourself or working with a lawyer to help you figure out those things, as opposed to just going to tell a judge, look, they violated the order. You must tell them how to fix it. And that's not always clear how to fix it.
It's not. And then, you know, sometimes you get really passionate about the violation and that's all you want to talk about. But, you know, the court needs to remedy the violation. That's what the court's really looking to do if the violation is provable.
Absolutely. Let's see. I saw some other questions here. My kids are 13 and 14 and need braces. I proved it's necessary, but dad wants to wait. What can I do?
What does your court order say about the division of uncovered medical expenses, assuming this is an uncovered expense, or maybe insurance doesn't cover all of it? So that there's generally a percentage division for those types of expenses. And so you would be able to notify the other side, look, you know, I'm moving forward with this and you're responsible for X percentage, and this is the amount I need you to contribute each month.
So let's say she has joint legal decision making. Your recommendation to her would be go ahead and get the kid's braces and then charge him based on whatever the uncovered medical expenses are. Is that right?
Yeah, I mean, I would tell him ahead of time, this is the direction I'm going in. I know you want to wait, but the doctor's recommending that we do this now. These are the reasons why waiting is problematic. And you know, this is regular medical care. You know, this is something that's needed. And this is what the order requires us to do.
I really like that perspective. So some lawyers would say you have joint legal decision making, you can't move forward without an agreement. But I really like what Julie is saying, which is no, this is not a major medical decision. This is a routine medical decision. I've got what I need to support my decision. I'm doing it. And you're on the hook for whatever percentage you're on the hook for. Somebody's going to have to go to court, and you'd rather not be that person that has to go to court, right? Now you're putting it on them to go to court, but you may have to do you may have to handle a lot of the appointments yourself. You may have to front the money and seek reimbursement. I'm not sure. Maybe the ortho provider would bill the other party, but I really like what Julie suggested there.
Well, the other thing too is the co-parent isn't saying, no, they don't need braces. They're just saying, let's wait. And so it's like, okay, there's no dispute that braces are needed. It's just the timing. And if you have support to show that now is actually the better time to do it for that reason, then, you know, then it's time to move forward.
Yeah. And that's a little bit of a risky decision. Some clients would be like, yes, I'm doing it. And other clients would be like, no, I'm afraid I'm going to get in trouble. And so you do have to sort of evaluate your own risk tolerance. But I agree. I think Julie's advice is spot on. Next question. If I have sole legal decision making that's been granted to me by the court, can I request a passport for my daughter by myself?
So you want to go through the passport agency and see what they require. But I would imagine you would provide a certified copy of the decree or order awarding you sole decision making, and that would allow the issuance just based on your signature. But you'd have to see exactly what the passport office requires.
Yep. Is there a spousal support calculator like the child support calculator?
There is. It's just not finalized just yet. Now, Billy, have you been playing around with it?
Yeah.
What are your thoughts?
Okay, so it's a lot. It's a lot of money. It is a lot more money than I ever see judges order for spousal maintenance here in Maricopa County. I was speaking with a person who is on the rules or the spousal maintenance guidelines committee. So they were part of the process that put forth these guidelines in this draft calculator. And they said, it's a mess. It's a mess. There's a ton of disagreement. It's really complex. It's a really challenging thing. But yes, there is a calculator. It's in draft form, but it is online. And I don't know, have you played with it? What do you think?
I haven't. I need to jump in and take a look.
So it's really interesting. You put in mom's gross income, dad's gross income. You put in your family size, and I think it's 2, 3, or 4 plus. That's your family size. And you also put in the principal paid towards your mortgage. So for instance, if my mortgage payment is $2,000 and 1,000 of that is principal, $1,000 goes in as principal, and it's added, if I'm the payor, to my income as available income to pay, because you're saving that money. You're not spending that money. Like it's not a bill, it's an investment. Then the calculator spits out a range: low, mid, and high. So in the example that I was working on yesterday, dad made about 400,000, mom made about 50,000. They have a 4-person household, and dad has a mortgage payment of that is towards principal of about 850. And the range, the low was like $6,200 a month. The mid was like 71, and the high was like 82. Which is crazy, right? Now, my understanding of what the guidelines say is the judge must pick a number within that range if they award maintenance. That is non-discretionary. What is discretionary is the duration. And they're only allowed to order up to a certain number of months, which is roughly, from what I'm seeing, about half of the marriage. They can award up to that amount, no more. And when we argue our factors, 319B, length of the marriage, health of the parties, ability to pay, when we argue those factors, it goes to duration, not amount.
Oh, interesting. So can you get an indefinite award anymore?
Yes, there's this thing in there called like the rule of 65, where you're adding the number of years married plus the age of the parties. And if it hits 65, then I think you can get up to, maybe it's retirement. I'm not entirely sure I haven't dove into that, but maybe not.
Yeah, because you could have 2 retired spouses who, cannot work for physical, mental issues, job market issues, whatever it is. And I'm curious, normally that would be a situation where an indefinite award would make sense, but I wonder if that's still available.
Right. Yeah, it's going to be really, really, really interesting. I wonder how close it is to being released or finalized. They had like an open forum last Thursday, but I couldn't go. So we will definitely report on this. It's a huge change, a huge, huge, huge change. I highly recommend people who are married and on the rocks or considering getting married to think about a prenup or a postnup, because it's a lot to give that amount of decision making to a judge or a calculator when you two are making decisions within your marriage about how you're dividing your careers, dividing your duties. Like, it's, in my opinion, it's worth truly understanding this and then making a decision about how you want to handle it.
Yeah, definitely. Otherwise, you're going to be subject to Arizona law, and you don't know if you're going to be happy with that or not.
Right. Let's take just one more question today. Somebody's asking, does your site offer still 2 weeks of our free trial for $1? Yes, you can go to our Facebook group, the Modern Divorce Support Group Facebook group, and you can it's pinned in there, a link to where you can get that $1 trial. Last question is going to be, if a long distance parent moves back, what happens to that parenting plan? Can they pursue split custody? Do they automatically get it? What happens?
Some parenting plans have a provision about what happens if the parent moves back. Otherwise, you can communicate to try to work out some sort of an agreement. Formally, your parenting plan should get modified at some point to match up with this continuing and substantial change in circumstances. But yeah, sometimes there's a provision that says, oh, if the parent returns, then we go back to whatever the parenting plan was before they moved, or we'll use the county guidelines that apply. So to see if that provision's in there. Otherwise, I think you're taking a risk if you're going to be like, oh, well, you're back, but you can't see the kids except for what's in our parenting plan until you modify. That could be used against you and backfire. I think your better strategy would be to start communicating, maybe start exchanging proposed parenting plans, see if you can reach an agreement to a new schedule.
Yeah. And also consider when you're making that long distance parenting plan, do we want to put in a provision for if the out-of-state parent or if the long distance parent moves back, or a provision that says, should the parties ever live within X number of miles of each other? It's not a bad idea to put that in a plan. If you know it's possible, you're saving yourself decisions and arguments that might happen down the road, or you at least have a de facto until, if in the event that happens, what the rules are, and then there's nothing prohibiting anyone from modifying if that doesn't work, but what it is.
Mm-hmm. All right, why don't we wrap up for today?
Yes, and so we are, our May is crazy. We're not back until May 25th. So the only way you can see us is at Women Without Law School or on the Facebook group, but it's been great. I enjoy this time with you, Julie, and I'll see you May 25th.
All right, sounds good.
Bye.
Bye.